circumstances where she cannot recognize her children. Her own children she cannot recognize, much less answer the question that was not put to her in the transcript. The judge, the court inquired, Judge Colabella inquired to Dr. Sivak. Did you ask her whether she... I didn't ask her. Why didn't you ask her? Because she could not answer the question. I hope that answers one of the questions posed before I got up. Your question, Judge Wachtler, as to what was said and its specificity, on page 17 of my brief, we set some of it out, and your question, Judge Kay, answer by Helen Hall, one of the daughters. My mother said that she was very glad to be home. This was in 1984. Very glad to be out of the hospital and hoped she would never have to be back in one again and would never want any sort of intervention, any sort of life support systems to maintain or prolong her life. If she can't take care of herself, she can't be independent like she has been all her life. She does not want to continue to live. She went on to say, I'm sorry, but that's because the witness broke down at that point. Going down to the bottom of page 17 of my brief, which refers specifically to the pages in the transcript, gives chapter and verse on that. In Christmas of '85, answer by Helen Hall, she said in the event she became ill and unable to care for herself, that she did not want any type of life support or sustaining life-sustaining system. Now, what she meant by that? Answer, you don't know. Question, you don't know. Answer, I can't interpret for her. Now, that's an honest answer. Incidentally, everything in this transcript, beyond being beyond the pale of review on a factual basis by this court.
It seems to me that there are at least two components to the specificity requirement. One would be specificity with respect to the type of life support, and the other would be specificity pertaining to the particular conditions confronting the patient at the time that the decision is to be made. Now, you argue, and I think with some substance personally, that intravenous feeding and that sort of thing may well come under what people refer to as artificial life support. But, and let's assume that there's enough in this record to answer that requirement. What about the specificity for the particular conditions confronting the person? This person is not terminal. This person is conscious. This person is not comatose or in a vegetative state. There is mental activity. And is there sufficient in this record for one to be able to say that she would have, under these circumstances, wanted artificial life support discontinued?
Judge, in this particular case, there certainly is that specificity, and I will get back to it immediately, but the problem I see in this case, if there is a problem, and it's not, hopefully not as an adversary, the problem in this case is my client's mother's background, and the problem in the DeLeo case is a doctorate in physiology. If the layman is going to be held to have to speak as a surgeon, then they will not be served, if that's well served, in my opinion, with the greatest of respect, if that is the decision that comes from this court. Now, yes, 2 degrees of specificity. The first one, I think, thank you, Judge, the first one, I think, should just be discarded. No one can list machines that we don't know that exist.
I don't want you to indicate that that's my position, but let's assume it.
All right, let's assume that the degree of specificity as to modality should be thrown out, because a layman doesn't talk like a surgeon anymore. He talks like a lawyer or an architect or an accountant about the accepted standards of whatever it is, accounting, if you would. They just don't talk like that. And the world we live in, of course, we try and regulate their affairs with the greatest of respect. And they're not regulating ours, except through a legislature who then becomes familiar, as the courts become familiar with our terminology.
It's got to be sufficiently specific, however, so that we know that the act or decision of the person is an act or decision of self-determination.
I mean, it's a long time, but she thought it was monstrous to keep someone alive by not natural means, by using machinery, things like that, if they were not going to get better. Acknowledged on the record before the Second Department as accurate and as truly stated.
That goes to modality.
That goes to modality, yes.
And
now
we're
let's
now going to address the
Second part.
temporal or condition
All right.
situation.
She wanted to die in dignity. What dignity is there with a woman who doesn't know where she is, can't identify her children, and cannot take care of herself? Let me seize on that one. May I seize on the last one? If she could, because it says it. I would never want to be a burden on anyone. No, better than that was where I read before. In this transcript, if we were to look at the transcript, Mrs. Hall testified about how this woman had an apartment until she was 72 years of age, and how she was very independent, and how in the course of these conversations, she drew on that feeling of independence to express it. Now, I am in this particular case right now, rather than in the statewide situation. What degree, Judge Hancock, of specificity, in the same sense as the modality, what degree of specificity is required? If the hospital room walls are pink, I'll go, but if they're white, I'll stay. If they can't communicate, if they can't recognize their loved ones. Now, someone...
Mr. Cohen, I don't think you really mean that. You can talk in terms of a condition where a person is, for example, unable to feed herself by virtue of a stroke and paralysis.
That's what I mean.
Unable to speak by virtue of aphasia, which could be a temporary aphasia, so that that person would then conform with all of the things which she said. She's not able to take care of herself. She's not able to speak. Certainly that person wouldn't want to die.
Your Honor, that depends on whether she clearly and conclusively expressed it beforehand.
All right, let's assume she said precisely what Mrs. O'Connor said. She said, if I'm unable to take care of myself, and if I'm a burden on someone else, I would just as soon die. Now let's assume right after that, she has a stroke, where she has a paralysis, which is diagnosed as temporary, but she can't take care of herself, and she can't speak, so she can't express herself by virtue of aphasia. Would you say that by virtue of her prior expression, she should now be allowed to starve to death?
There has to be added to that equation something about a recognition that they will not get better, because what you put into the pot to boil, Judge, was that the person may get better. And that's a different situation, and there's got to be a clear and conclusive thing, and then...
All better? All better?
Judge, how...
Are we going to evaluate what the quality of life is to be?
Judge Colabella, on this record, during the county summation, said that what the county was maintaining in this particular case was too exacting. That was his exact words, too exacting. What the inquiry to be made by this court and the definitive proclamation to be made by this court to serve the people of this state requires a declaration of something in layman-like terms. What would be sufficient for a layman to say? I think it would be an acknowledgement that if they are not terminally ill, they will never get better and are not in the kind of a situation where dignity applies, where they cannot take care of their own basic needs and cannot recognize their own loved ones and cannot communicate on any kind of a coherent basis and will never get better than that. Stora was far less than that. Stora was an application by his mother to have blood replaced in a person who walked and talked. He never made sense, and therefore, under our law and under the absolutely consistent dictates set down in Eichner, Stora could not, the Stora application by the mother, the only living relative, could not be granted because Stora had never been in a condition to say it. What specificity? There cannot be a getting better. That must be added.
Is it necessary or unnecessary or relevant or irrelevant to you that the doctors found she suffered from serious dementia because of a series of strokes here? Or is...
Absolutely relevant, Your Honor, because when they were both asked, both Dr. Wasserman and Dr. Sivak said, this woman will never improve from this mental condition. Now, what this woman said is, if I don't want to be a burden, I don't want to lose my dignity, she said a little more than that. She thought it monstrous to keep someone alive by not natural means. Lampasso discussed it with her when she was nursing her brain cancerous husband who was terminal, and she said she never wanted to be in that condition.
Were all her expressions, to come back to Judge Hancock's second prong in terms of the specificity with respect to condition, state of a medical condition. Were all of her expressions made in the face of dealing with a terminally ill person?
They were made in the face, well, I guess they all died.
Because doesn't that, though, lend some relevance and understanding against to her expression and decision, whatever it was, hers, as an act of self-determination?
Judge, on this record, with this case, when Dr. Sivak was asked, how long does she have to go without this? He said 2 months, but off the top of my head, maybe 2 years.
Off the top of his head, but if and you use the word dignity, and I ask you, the dignity of death for someone who is conscious to be starved and of thirst, to die that way, dignity to whom? To those who would observe her, or to both?
Look, Judge Bellicosa, if someone who is perfectly competent and can talk, has the right in our state to refuse medical treatment, and someone who is in a persistent vegetative state, who has said it clearly and convincingly to refuse future medical treatment, what rationale is there in this court,
Well, the
both
rationale-
of those decisions, to differentiate with this woman?
Oh,
That
Mr.
is
Cohen.
that's not asked of you out of passion. It's asked out of relevance to the
Yes.
question that Judge Hancock raised about the context and condition of the individual requiring some specificity in relation to the
See,
modalities.
Mr. Cohen, in that connection, just to piggyback on that, in the Eichner case to which you just alluded, there was such great specificity because it fit like a hand in a glove. He was talking about precisely that condition as it precisely afflicted someone else, and lo and behold, he finds himself in exactly that condition.
One of the problems that brought us here is the specificity in Eichner. Obviously, I just heard that too. I'd like very much to be able to completely answer your question. In this case, Judge Bellicosa, in this case, this woman is not comatose, but she can't ask for water. I don't want to be repetitious. She can't recognize the loved ones. She can't ask for water. She has, without this artificial mechanism, whatever it may be, IV feeding, not an IV opening an IV, but IV opening as a pathway and then feeding into that pathway, or nasogastric tube. Without that, she has 2 months, or off the top of a doctor's head, 2 years. You may want to, in your opinion, address what is terminal. What is terminal? But someone, look, in Quinlan she went on and she lived, all right? About someone with dialysis, with non-functioning kidneys, kidney may or may not come back. I hope I am answering your question.
Yeah, but there's no question here that the withdrawal of food and water is going to bring about her death in 7 to 9 days, I believe.
There is no
7 to 10, as compared to the removal of a respirator
Yes,
or
she
dialysis.
cannot eat. She cannot perform her basic functions. Didn't she say that if, in words or substance, as a matter of law perhaps, if not of fact, didn't she say that if she couldn't take care of herself, now what is the inability to feed herself, to reach from her hand from her plate to her mouth, or to put anything in her own mouth? If I can't take care of myself, now what standard, it's exactly like the modality, I agree, what standard must the layman be held to before they can say that they want to go out in dignity? Do they have to be terminal? Do I have to be terminal to refuse penicillin? Do I have to be terminable to refuse a new kidney if I already have one functioning? What's the rationale for differing with that?
You had the same statements of the patient here, and she was in the condition that existed in the Brophy case, which as I recall it, is a comatose vegetative person and so on. You would argue that there's no question, but she had that situation in mind. Now, if you had the Conroy case, which I think is somewhat worse than this, you may make a similar argument. But the situation here is not Conroy and it isn't Brophy. And the statements which were made, you could say, yes, I think she must have had in mind exactly the same situation that you've described. She can't feed herself. She can't help herself. But isn't there some ambiguity about what condition she had in mind when she made those statements? And if there is some ambiguity and some doubt, has the clear and convincing requirement been met?
I think that the clear and convincing requirement in this case has been met. I think that you have a woman who cannot walk, which is one of the reasons she went into the Ruth Taylor Institute. You have a woman who cannot eat now. You have a woman who cannot talk. They say she responds simply 50% of the time. That is the grossest of overstatements on this record. They can't ask her anything. They can ask her first name. She does come back with her first name. But and I'm no neurologist like Dr. Wasserman and so on, perhaps that's the most dominant part of one's intellect in one's brain, your name. Certainly, she doesn't know who the President of the United States is. She doesn't know the name of her doctor. There's questions whether she recognizes a doctor who comes in to see her. Did this woman in particular envisage this particular type of a situation? We say by the testimony that these they may be licensed practical nurses, that these lay people said. Judge Colabella asked, isn't it ridiculous to talk amongst children and a parent? Isn't it unrealistic to think that they talk in that kind of a detail? Not now modality maybe, but maybe condition. If I can't care for myself, is that enough? But you're saying maybe she's not terminal. I must come back with 2 months off the top of my head, 2 years. This woman has had a series of strokes. They thought she had a stroke when they rushed her into the Westchester County Medical Center in June, and she wound up having pneumonia instead. I think that in the briefest of terms, I think that in DeLeo, they spoke about that, Judge Bellicosa, about people who might not even be terminal refusing this kind of treatment and allowing.
Except he was neocortally dead.
Yes, but they weren't talking about DeLeo himself, the doctorate who was young and neocortally dead. There was some dicta in there about people who were not terminally ill, and it may be a service to apply some of this reasoning, but they were not talking about substituted judgment. I think I refer you to that. Forgive me, I can't marshal it all now and just spew it out. It's in there. I know it's in there somewhere. And
You've read it, and I've read it, and probably everybody.
Yeah, and I just wanted to mention it. I just didn't want to. I thank you so much.
Thank you very much, Mr. Cohen. Lansner versus DeSapio. Mr. Muir, you know our interest in this case is a very narrow one.
That's correct, Your Honor.
We've read all of the issues, we've read the briefs, we understand what you've argued or what you would want to argue. We are concerned only with the standing issue.
That's correct. I think I much prefer to follow a contract case following the last argument before this court. Feel somewhat...
It might come as some surprise to you to know that we feel the same way.
as bad as it is being on this side, I will tell you why, quite frankly, prefer to be making the decision on this side rather than on that side of the bench. The permission to appeal and motion to appeal was granted as to the question of standing solely, and I will confine myself to those aspects. The question of standing, clearly, this is an Article 16 proceeding under the election law. Question of standing being who has what right to come before the court and what questions may they raise. Generally and specifically, what question was put before the court in the instant proceeding. In the original order to show cause and verified petition, the request was made that the court review erroneous determinations on several questions made by the Board of Elections of the City of New York. The petitioner in this proceeding had in fact defaulted willfully and as a conscious decision at the hearing before the Board of Elections. It is appellant's position herein, as it has been throughout this proceeding from special term on up, that the failure to appear and proceed at the Board of Elections, having had notice that objections were filed and that a hearing was being held, deprived the petitioners of the standing to proceed to Supreme Court and ask that court to review the decisions having been made by the administrative agencies. This is not a position that is unique to the election law, but in any administrative proceeding, when one seeks the court intervention in reviewing an administrative proceeding, in order to have standing to go into court and have the court review, one has to have exhausted the administrative proceedings that are prescribed in the statute.
I think the court's focus is on the fact that some 200 petitioners are listed and that the petition was only verified by one of them.
I will confine then to that specific area of the standing. The proceeding herein was commenced by one candidate for county committee, there being 216 candidates in 72 election districts, representing 144 separate categories, being 72 male and 72 female. The proceeding was commenced by one petitioner, although the caption says David Lansner et al., see attached list, and attached to that list was just a copy of the list that had been filed with the petition. It is appellant's position that at best that presents a situation where the verification was made by the one moving party, being Mr. Lansner, puts before the court Mr. Lansner's candidacy, or at best the others seeking election to members of the county committee from his election district. There have been cases that hold that where there is a unity of interest and everyone is in exactly the same situation, one can bring a verification by one as effectively a verification for all. However, these are candidates for separate election district county committee seats. These are not candidates that appear on all of the pages of the petition.
Right.
The other cases that are cited in the brief and have been explored by this court deal with a case where all of the candidates appear on all of the pages of the petition and are therefore united in interest, and the proceeding can go forward.
Is that not the case here? I'm not clear on whether the petitions under attack contain the names of all the petitioners.
No, the county committee, each election district has a number of pages within the several volumes. There are, I believe, 7 volumes in total, totaling several hundred pages. There are 4 pages for the first election district. There are 3 pages for the third election district. There are no candidacies that appear on all of the pages.
You would
of the
require
petition.
144 separate petitions?
I would require at least the 72 separate petitions if, in fact, we are seeking to validate all of the county committee seats. To hold otherwise, to carry to its logical conclusion, would mean that any one person anywhere in the county could bring a proceeding to validate all of the county committee petitions within the county. While the petition for each group of candidates, for each series of county committee seats, if you will, are separate petitions, they can be bound together into one volume because of the other offices, and they all get filed into one place. But they remain separate petitions. This is not a case where the district leader, if you will, who runs district-wide, appears on all of the pages and therefore is united in interest on all of the pages throughout the district. Here, we cited the Vaccaro case, which this court had decided several years back, but in the Vaccaro case, they held that you couldn't move to validate judicial delegates county-wide by having delegates from one district petition on behalf of all of them. Here, while they're not judicial delegates run one entire assembly district, they said you could not move for the entire county. Here, they're saying that when you are from one election district, you lack the standing to move. We are maintaining, when you're from one election district, you lack standing to validate the petition as to the entire assembly district, or in fact, anything beyond the election district in which you run. Just as if you were seeking to invalidate the petition, necessary parties would require that you serve all of the candidates in all of the districts. You can't serve one of those people in a representative capacity, if you will, on behalf of everyone, because they are not united in interest. The petitions rise or fall as to each individual county committee designation, and the number of signatures are different. The number of seats are different. In some EDs there are 2 seats, in some EDs there are 4 seats. The number of signatures are different in each and every case.
Well, there's not a perfect parallel, though, to a petition to invalidate, where you would want to be certain that notice were given to the person whose petition was sought to be invalidated. You don't have that concern for notice, particular notice and prejudice here.
No, we do not have the same notice
Isn't it
problem.
sensible, then, to permit a single proceeding to proceed on behalf of the 144 separate candidates instead of to require 72 or 144 petitions?
We believe under the present statute it is not allowed or acceptable under the law, that they are separate petitions and they remain separate petitions, and when you bring a proceeding to validate the petition, as to each election district, they remain separate and distinct petitions. Those petitions, unlike other different petitions, may be bound together because of the district-wide offices that are contained thereon, but they still remain a separate petition for all purposes. And to have standing to validate the petition, all you are validating is the petition for that specific group of candidates, for that specific seat, for the county committee. Otherwise, the question is, where do you cut it off? Can I bring as one candidate for county committee in Kings County? May I bring one proceeding to validate all candidates countywide, which is some 2,900 election districts, or where does it stop? It is a separate and distinct petition and must be proceeded.
Is it clear that you raised and preserved this contention?
It is absolutely clear in our opinion, Your Honor. If you look at the conclusions in the brief that was filed in trial term, it is one of the conclusions that was asked in trial term. In the appellate division, in our brief, we raised it also in our brief. In fact, counsel handed to me this morning a copy of his reply brief at special term, wherein he replied specifically just to the standing question. The question of standing has been raised throughout, has been maintained throughout, and we believe is a valid question.
Thank you very much, Mr. Muir. Mr. Osofsky?
Thank you, Your Honor. May it please the Court, my name is Paul Osofsky. I represent the candidates. It is always an honor to appear before this Court, and as Mr. Muir says, somewhat humbling to have to make this argument after the one that we've just heard, and I hope that I'm up to it. There is no standing issue here. And to address that, I think we have to divide this into 2 separate questions. Number 1 is who are the parties? Number 2 is who may verify the petition. And I think that once those 2 issues are separated, the Court will have a clear path to the decision. Clearly, all of the petitioners had standing to validate their own petition. So with respect to this branch of the question, the only issue was whether or not they made themselves parties. And in determining whether or not they did, we should start with the caption. And one looks at the order to show cause and the petition in this proceeding, which is in the file. It says, in the matter of David Lansner and each of the individuals listed on Schedule A to the annexed petition. And when we look at the caption of the petition, it's in the matter of the application of David Lansner and each of the individuals listed on Schedule A to the annexed petition. Done that way only so there wouldn't be a caption that had to list 218 names. But it is clear that the intention was to name all of the individual candidates as parties petitioner, and this is not a situation in which Lansner is purporting to represent himself in the nature of a class action individually and on behalf of many other people. And as one goes through the order to show cause and petition, all of the allegations are consistent with that.
He verified
Yes, now
on
if
behalf of all.
That is correct, and that, Your Honor, with respect to that, let's move to that issue because it seems to me that is a wholly separate issue and that we can get rid of the question of standing as such because I believe there is not a literal standing issue. They're all here. They were all parties. CPLR 3020D provides that if all parties are united in interest, then one of the parties may verify the petition on behalf of all of them. And that's what happened here. When one looks at the verification in the petition, David Lansner, being duly sworn, deposes and says, that he is one of the petitioners in the within proceeding. He's read the foregoing, he knows the contents. And there is a consistent line of decisions, as Mr. Muir indicated. What happened was, when we appeared at special term and argued before Judge Slavin, Mr. Muir did not make this point on oral argument, so that when he submitted a memorandum of law which raised this issue in one paragraph, I submitted a reply memorandum of law addressed to this one issue, which is in the file, and I handed a copy to Mr. Stranad this morning for submission to the court, because I did not realize until Your Honors said that you wanted this issue addressed and it wasn't addressed by the appellate division that we would be here. But there is a consistent line of cases, 7 or 8 or 9 of them, including some of them from this court, the last one, Castillo against McLaren, in which, when one looks at the facts of all of those cases, that there are candidates who are not running for the same office. There are, in fact, 2 cases cited in there, one from the First Department and one from special term at Queens County, which involved exactly this situation. One candidate for county committee verifying the petition on behalf of candidates for county committee in many different election districts. One case in which there was a candidate for state senator verifying the petition on behalf of himself and a candidate for borough president, but they were both on the same petition.
These are different positions, different party positions.
They are,
involving I understand from Compton's argument, separate petitions. And so can it be said that there is a unity of interest so that it's possible for one to verify for all?
The answer to your question, first, Your Honor, is yes. They are candidates from separate election districts, but as is permitted by the rules of the Board of Elections, they may be incorporated within a petition with other candidates from greater jurisdictions, so long as you have on the cover sheet of the petition a schedule setting forth the pages on which the signatures from each election district can be found.
As I always understood the rationale, if regardless of the positions a candidate's seeking, if they're relying upon the same signatures, then they are united in interest. But if they're not relying upon the same signatures...
Well, Your Honor, let me put it a different way. They are all within the same petition, and the issue that was raised in the court below goes to the validity of the entire petition, which is whether or not the sex of the candidates was required to be placed on the cover sheet of the petition. That was the only substantive ground of attack. That issue unites all of the candidates in this one petition. A decision on that one issue will allow all of the candidates to stand together or all of the candidates to fall together, and it relates to the assembly and the cover sheet of the entire petition. It may be, without conceding the point, that if there were separate challenges to the validity of signatures with each county with respect to each election district, that a different issue could be raised before this court as to whether or not the candidate who verifies the petition could have knowledge of the facts with respect to all of the other election districts. But because no individual signature was challenged here, and each petition contained, each election district contained more than enough signatures to qualify the candidates for the ballot, and there was one set of objections filed against all of the county committee candidates, which was confined to one ground, it seems to me that there is no issue, at least in this case, with respect to the unity of interest of all of those candidates. And once again, I point out, Your Honor, that if you look at the decisions which have preceded this one, if the court were to take a narrower view of this question, it would require them, I believe, to overrule a number of decisions which at the very least have been affirmed by this court, whether or not they were addressed by full-blown opinions. And finally, I guess I would say, Your Honor, that it seems to me that if there is any doubt as to what position the court should take, it seems to me that the court should adopt that position which would allow a candidate who was aggrieved by the decision of the Board of Elections to seek judicial review, or else we would be in the position that Judge Kaye suggests, in which we would have to find at least 72, maybe 144, and perhaps even 218 candidates to come in and each sign a verified petition and maybe each pay $150 in order to show cause in a request for judicial intervention. Maybe I shouldn't say that. The court's whole budget would be able to be met by the filing fees for the member of the county committee.
I don't think we'll ever make it on election cases.
I wish we didn't have to. I wish we didn't have to bother you with these, Judge Bellicosa.
No, that wasn't meant as a rebuke about the cases. I was playing
understand.
off your comment about how much money can be generated.
I understand. I just want to say, finally, that I understand, and I'm not familiar with the facts, I understand that there is another case from the Bronx that the court is about to hear called Collins, which raises a similar issue.
Hang around.
What?
Hang around.
Okay, and the reason I point that out is because my understanding of the facts in that case was that in that case the petition was subscribed by one of the petitioners and verified by one of the petitioners, not saying it was being done on behalf of all, and not subscribed by an attorney in the first instance and verified by one of the petitioners, as happened in this case, so that it would be possible to reach one decision in this case and another decision in the Bronx case without being inconsistent and without meaning to take a position on what the court should do.
Sounds like you're distinguishing a case that hasn't been decided yet.
I can't anticipate what's coming after me, so I'm doing my best.
Well, the one after you comes out the other one.
Thank you very much.
Thank you.
Thank you.
Thank you very much.
Collins versus Marchi. Mr. Victor?
Thank you, Your Honor. I was about to open my remarks by a statement saying I adopt Mr. Paul Osofsky's arguments in toto. I have to amend that. I do certainly adopt his arguments as they relate to the issue of standing, but his distinction of our case with his is totally inappropriate.
Is there any factual distinction between the two?
None whatsoever. You just look at the petition. It names all of the parties as petitioners, and it was specifically verified by one of those parties on behalf of all. There is absolutely no factual distinction whatsoever.
Is there an indication that it's on behalf of all the parties?
Certainly.
What about the issue? Is it a common issue as it was in that case?
In our case, the common issue here is as to the qualifications of the objector. Every single county committee person who is a party to this proceeding raises that same issue. They are all united on that one issue against the qualifications of the objector. They do have a unity of interest
There were
in these
individual
proceedings.
issues as well, though, in your case, were there not?
There were, but they are not before the court. They're not the subject of this particular appeal.
They're not before this court, but they were before the court initially, were they not?
Yes, they were.
And then isn't that a material distinction from the prior case?
I don't believe so. I believe that they are, again, all on the same petition, bound within the same volume, and I think their interests were all united at that particular time. But we have in addition, I think everyone overlooks the fact that parties may appear by attorney in proceedings, as stated in Section 321, I believe, of the CPLR. And all of these individual county committeemen appeared by attorney in these proceedings. Again, we divide out the requirement for verification. Only 3020 subdivision D of the CPLR deals with verification. And it states that when there are more than one petitioners, only one need verify. And that's exactly what occurred here. All of the parties appeared by their attorney in a joint petition brought on their behalf, and only one party verified. And there were many objections, including this one objection which they were united in interest in. So I think it was a proper joinder, and I submit to the court that there is standing. Now, ironically, about 3 or 4 years ago, I was on the other side of this issue, asserting the Williams against Vaughan case. And there we argued that there was an inappropriate joinder. And the appellate division there, citing I believe the Maniscalco case in this court, and Leveri against Gargiulo, stated that you can have multiple petitioners and only one need verify where they have a unity of interest.
May I ask why?
In losing that case, I relied upon those cases in structuring the complaint or the order to show cause in this case.
Why do you refer to this issue as standing? Isn't it really a procedural defect, a verification?
Well, okay, it's not I just don't adopt the language that it's a defect. It deals with who must verify. CPLR 3020 subdivision D states only one of the petitioners need verify when you have multiple petitioners. It's not a defect. But the issue deals with an allegation of defect based upon a single verification.
I'm not saying it is a defect, but it's an alleged
defect. And the court...
Procedural matter, not really good. If I understand you correctly, there's no problem as far as parties go. The people seeking verification are all parties.
Absolutely. It is a procedural matter in that regard.
You have another issue as well, Mr. Victor.
Yes, the other issue is one of first impression for this court, and it deals with the qualifications of an objector, and whether an objector may challenge all county committee persons within the assembly district, despite the fact the objector only, of course, resides in one of those election districts. Now, prior to 1978, there was no legislative statement with regard to the qualification of an objector, and the courts crafted some rules with regard to it, and specifically with regard to the qualifications of an objector for county committee. The courts held that if the objector resided within the assembly district, the objector could then challenge any county committee person. In 1978, that law was changed, and in very clear and unequivocal language, the legislature stated, and that's in 6-154 subdivision 2, that in order to challenge a party position, an objector must be enrolled to vote for such party position. I mean, there is no more clearer or more clear language than that. The one case then that interpreted that section and this objection to qualification was the Maslow case, which came a few years later and recognized the change in the law, but just chose not to follow it, stating that in our view, this section did not mean to change the prior well-settled cases. Well, of course, the prior well-settled cases were prior to the legislation. They were therefore irrelevant to the legislation. And we submit that that court was clearly in error. Now, that case sometimes finds weight in the lower courts because appended to every citation of the appellate division's decision in that case is, and leave to appeal to the Court of Appeals denied, well, impliedly stating that this court has reviewed the merits of the decision and rejected them. Well, it's not so, because if you look at the reason given by the court in not taking the appeal, it was for jurisdictional reasons. Apparently, when the appellate division in Maslow reversed the lower court, it remanded the case for a new hearing. There was no final order which could be appealed either as of right or by permission to this court. And this court, therefore, for jurisdictional reasons only, refused to hear any appeal on the issue. So the merits of the issue have never been before the court.
Even if the court had denied leave for other than jurisdictional reasons, it would be meaningless as an expression on the merits, wouldn't it?
Well, yes, but I think having denied it for jurisdictional reasons, it's a stronger argument. Now, in this particular case, we had a referee's report that had recommended and adopted the argument given by appellants in this proceeding, that the objectors were not qualified to make the objections. The lower court judge, sitting in Supreme Court, Judge Rosado, sitting in the first department is a second department justice on temporary assignment to the first department, and he stated he was constrained to follow Maslow, and did so because of the Maslow decision. We submit that Maslow is an error and should not be followed, and therefore that the appellant's position should be adopted by this court in the matter reversed.
Thank you very much, Mr. Victor.
Thank
Ms. Coyle, the language is very clear, is it not?
In 6-1...
Registered to vote for such public office, 6-154-2.
Yes, Your Honor, it's the party position that we're talking about in 61542. The language is quite clear, but I think it's quite clear on my side. The issue of a county committee person, someone who's a county committee person is a county committee person from the 80th Assembly District. You run within the 80th Assembly District. What you do is, for convenience sake, you are allocated the 1st District, the 50th District, the 18th District.
But someone in the 5th District cannot vote for someone in the 8th District.
No, you can't vote for, however, you can run in a district other than from where you live. For example, I'm from the 50th election district, and I can run in any election district in the entire assembly district. Indeed, not only can I run, but I can even qualify signatures in other election districts within the 80th Assembly District. So the legislature is not intending to take away my right to object as the county committee person in the 50th election district, because it's a convenience factor that I run from the 50th election district. No more than that. I could run from the 25th election district.
Well, what was the purpose of the amendment then?
If you look at the Bill Jack, the 6154, the recodification to 6154 made a lot of changes to the election law. If you look at all of the legislative history, nowhere does it say that we are taking away a right of somebody who is an objector, somebody who is a state committee person. We're taking that person's right away to object in any other election district. That would be a substantial change. But it does not say anywhere that that's what was intended.
But aren't we obliged to give some effect to the words that were used by the legislature, and indeed to the fact that they specifically made an amendment to include these words?
The section that you're referring to, Your Honor, doesn't say that I can't object in another election district. It just says if I do object, I have to be qualified to vote to vote for that particular office. That particular office is county committeeman or county committee woman. And we have in this state been operating for more than 20 years under those rules.
You don't think such party position, and that's the wording, refers to the office being challenged, the specific committeeman being challenged?
No, Your Honor, I don't. And when the county committee people do whatever the county committee people do, and that is meet once or twice a year, they do it as a body from the 80th Assembly District. We're county committee people from the 80th Assembly District.
Except that the residents of the 3rd election district and the 80th Assembly District have a right. They can only vote for those county committeemen within that district.
They can only, Your Honor, you're right, they can only
But
vote for those running in that district.
running in that district, so that under your formulation, someone in a different election district can affect the county committee person from a different district, because he can challenge that person. If successful, then the person in the 50th election district is determining who the county committee member would be from the 3rd election district.
But we're also...
That's not consistent with the statutory scheme, is it?
No, I don't believe it is, because what we're trying to do is elect candidates from the Assembly District. Nobody really cares who runs from which election district. In fact, what happens most of the time is that you have to fill in the gaps. So people from the western side of the district run in the eastern side, and you just push them into whatever gaps there are. So when you say one person would have the right to object to the candidates from the 50th election district if they're from the 5th election district, we have, if you're from my political persuasion, an interest in ensuring that the candidates who run for county committee are good candidates, are qualified candidates. We don't care that we don't care that we are objecting to them from different election districts. We want to get rid of all of them, whether they're from the 50th, the 49th, or whatever. Our interest is getting rid of as many as the opposite side candidates as the opposite side has. That's what our intention is in these election law cases. That's what Mr. Victor's intention is in these election law cases. The point of 6-154 and what the court says is such office. The office is county committeeman. There's nothing...
But if the legislature had intended your reading, wouldn't they just have said enrolled to vote for any such party positions in order to embrace all and to allow the crossovers? Whereas saying enrolled to vote for such party position has such a degree of specificity that their intention, seemingly very plainly expressed, would seem to cut back on your opportunities, albeit understandable in terms of affecting other positions. It seems to me that when we're confronted by that language, we've got to consider whether we give it any meaning or not.
Well, I think we would give it, if what you're suggesting is so, you would have to agree, as I said before, that that would be a substantial change. And nowhere in the legislative history does the legislature or any memoranda on the subject say, we are intending to change established law on this subject. And as I said, we've been operating for 20 years like this. So everybody has been assuming that one objector, and has been operating that one objector can object to all candidates for county committee who are running from the 80th Assembly District or the 79th Assembly District. The intent of the recodification was not there to change the entire election law. That's not what it did. What it did is change some particular statutes. And if, as I said now twice, and I'm repeating myself, if they wanted to do something as dastardly as that, they would have let us know that's what they were doing, and there's nothing in the history to say that's what it is. More importantly, I'm an 80th Assembly County Committee person, and I have an interest that all of the people who are county committee from the 80th Assembly District are good people, honorable people. Now, not all of the candidates running from my opponent's side are dishonorable, but I certainly don't want them running as county committee people. I want to get rid of all of them. A clean brush is what I'm trying to do.
Even the good ones.
Well, we have better ones. That's what it is. We have better ones. The other part is that if we had to have objectors from each of the election districts, we're talking about, in my district, 102, 103 objectors. So now we have to have 103 objectors coming in, 103 objectors from the 80th, 100-something from the 79th, multiplied times all of the assembly districts. The volume of paperwork on the Board of Elections would be enormous, and it would not be in keeping with what we hope is the intent of the election law, and that is that as many good people get elected as possible. That is funny, and I withdraw it.
Ms. Coyle, other than the Maslow decision, are you aware of any judicial construction of this provision in the 10 years that it's been in operation?
No, Your Honor, I don't think there has been any construction. There was a pre-codification decision called Elovich that cited in the briefs, but nothing since. And that, again, is what I'm saying. We've all been operating under this for so many years.
Do we know whether we've been operating one way or the other? The record seems inconclusive.
Yes, we have been operating that one objector can object to everybody. That's correct. If I may go to the issue of whether one person can verify for more than one candidate. In our case, in both the 79th and 80th, we had one candidate, one county committee candidate who said, quote, that she was endorsing, quote, on behalf of all said candidates. That's fatal. In our jurisprudence, you can go two ways. You can either go pro se, or you can hire an attorney, and that attorney represents you. Elizabeth Amer, who is a county committee person, and whoever it was in the 79th, is not an attorney. They cannot represent in this court that they are acting on behalf of other people. That is practicing law without a license. There was no implied consent. There was no consent by any of the other county committee candidates that they were allowing themselves to become party to the lawsuits.
Thank you very much, Ms. Coyle.
You're welcome.
Just two brief rebuttal remarks, if you want, please.
You still have some time left, yes.
My opponent has asked this court to equate the qualifications of the candidates qualifications of the objectors. Now, we have two different divergent statutes that deal with each of those qualifications. Section 2-104 specifically permits anyone living in an assembly district to be a candidate for county committee anywhere within the assembly district, whereas 6-154 subdivision 2 specifically states that an objector must be enrolled to vote in the election district for such party position.
Just have
You
one
different sections.
question on these sections. Can someone who does not live in an election district but does live in the assembly district sign a petition for a particular district committee?
No,
Other
you
than
must reside within that election district
order
to
to
sign
sign as a
for a county
petition.
committee. That's clear.
Thank you very much. Mr. Victor?
Thank you.
Lucariello versus Niebel?
Ready to call, please.
Mr. Bluth? We just heard the law articulated, both pro and con. Have you got anything to add?
Yes, Your Honor. I've listened with interest to the arguments before me on this particular issue, and we're focused on the issue of can a county, an enrolled member of a political party challenge other candidates for county committeemen outside his or her own election district, but within the assembly district. And you have focused on 6154 too. What I ask you to do, Your Honors, is to take a look at the background of where that section came from and the background of where the case opinions on this issue have come from. One of the leading cases that's been cited on this issue is the Mahoney versus Lawley case. It comes from this court in 1950. That's the threshold case which allowed someone to challenge a committee candidate within the assembly district. And if you look at that opinion says that it's based on the ability of the potential objector to run anywhere in the assembly district. But that opinion further states the rationale for allowing that, which later became the law, by saying that in that respect, this proceeding accords with our decisions that a voter who has the capacity to vote for a candidate in the political unit involved is a person aggrieved within the meaning and intent of Section 330 of the election law. Now, that's on page 427 of the Mahoney versus Lawley opinion. I would urge this court to read that over before you make your decision, because what in effect happened when the legislature later made that very language the law in 1978 was they were putting into the statute what this court had interpreted the proper standing to be an objector to be.
They never said that explicitly in the legislative history.
They never said that, but the interesting thing is I have the legislative history with me, and I've looked it over, and this 1978 bill, which added this specific language we're looking at, which was not in the 1976 attempt at recodification, but the 1978 says that this is a technical corrections bill. It's right on the bill jacket, and it's right on the memorandum that were submitted in support of the bill. It deals with typographical and spelling errors, omissions are repealed. The cover of the bill says it's an act to amend the election law in relation to making technical corrections in the recodification of such law and to repeal certain provisions thereof and relating thereto.
And so it's your contention to this court, Mr. Bluth, that this affected absolutely no change in the law, but was precisely how the law was being administered up to that point.
That's correct, Your Honor. And
it has been so administered ever since.
And that is correct, Your Honor. That is precisely my point, and that is the point that I believe the Maslow court considered when it stated that the they felt, meaning the Second Department in the Maslow case, that the enactment of the new law was not intended to change the well-settled law. Now, you may be hearing in my case that, well, this will lead to an outrageous circumstances of two petitioners coming into court and challenging 245 potential candidates. In my case, the challenge is by one petitioner who is in the 149th Assembly District, one petitioner who is in the 150th Assembly District. And the basic challenge is to a bound volume of designating petitions for a county committee that were submitted without regard to Assembly District and were just alphabetically by town within Chautauqua County. It turns out on later review, only 188 of those respondents are within that bound volume, and therefore on the merits, the case would be dismissed against the remaining. But the merits of this case have never been reached because special term just dismissed on the standing question. But ultimately, the merits here deal with two petitioners, one from the 149th and one from the 150th, dealing with this volume that's bound and doesn't in fact become one petition, because the election law says that they may have been able to be submitted individually without being bound, but under 6134-2, if they're bound, then and they contain more than 10 sheets, which these obviously did, then they have to have a cover sheet. And so we may end up being back up here on that issue once the case gets decided on the merits. But if you look on this standing question, if you look at the history...
Sounds like an interorum argument.
That's right. And quite frankly, the cases throughout the 60s, the 70s, and the 80s, other than the Fourth Department opinion that I'm here appealing today, all the opinions have allowed this standing to object within your assembly district.
Is there any legislative expression in history or otherwise, or judicial expression, that the statutory amendment was a codification of the Mahoney case to which you alluded, as opposed to an overruling of prior law? That has a different perspective to it in terms of the history of the rule that's involved.
The only reported case